Shri Babu, Land Council for the revision petitioner. And what's your good name?
Nagaraj Reddy.
Nagraj for respondent. First, next para. Revision by the accused who suffered an order of conviction under section 138 of the Negotiable Instrument Act in CC number 9616 of 2018, confirmed in criminal appeal number 300/2021. First, facts of the case in brief are as under. Respondent complainant filed a complaint under section 200 CRPC with the jurisdictional magistrate seeking action against the accused for the offence punishable under section 138 of the Negotiable Instrument Act. First, complaint governments further reveal that accused is the owner of various houses constructed in property bearing municipal khata number 8323/so-and-so so-and-so. Note hakotimma. So-and-so. First, situated at Vishwesvaraya layout next to CSI Hospital, Hoskote Town, Bangalore Rural District. First, next para. Complainant became lessee under the accused in respect of one premises on 17/11/2013, and a lease deed was also executed in this regard on 1/12/2017. Full stop. Because of the financial necessities that the accused pleaded, complainant parted away sum of rupees 4 lakhs on interest with 2% per month, agreeing with a promise to repay the same within a short period. First, towards the repayment of the said loan amount, accused passed on a check bearing number 574,063 dated 5/1/2008 in a sum of rupees 5,50,000 representing the principal and interest amount. First, the said check on presentation came to be dishonored with insufficient funds, and later on legal notice was issued. First, next para. Legal notice was duly replied by the accused denying the amount covered under the check, and also contended that there is a misuse of the check. First, therefore, complainant sought for action. Next para. Learned trial magistrate took the cognizance of the aforesaid offence and secured the presence of the accused, and plea was recorded. First, accused pleaded not guilty, therefore trial was held. Next para. In order to prove the case of the complaint, complainant got examined himself as PW1 and placed on record 11 documents which were exhibited and marked as exhibit P1 to P11. First, thereafter, accused stepped into the witness box and got examined himself as DW1, did not place on record any documentary evidence. First, accused statement as is contemplated under section 313 CRPC was recorded, wherein accused has denied all the incriminatory circumstances found against him. Next para. Thereafter, trial magistrate heard the parties and noting the matter law on record, raised the presumption in favor of the complainant under section 139 of the Negotiable Instrument Act, and also took into consideration the arguments made in the reply notice and the oral testimony of DW1, found that the evidence placed on record by the defendant accused is not sufficient enough to rebut the presumption available to the complainant under section 139 of the Negotiable Instrument Act, and convicted the accused for the offence under section 138 of the Negotiable Instrument Act, and imposed the fine of rupees 5,50,000. 5,60,000, of which sum of rupees 5,50,000 was ordered to be paid as compensation to the accused, and balance sum of rupees 10,000 as fine towards the defraying expense of the state. Next para. Being aggrieved by the same, accused preferred an appeal before the district court in criminal appeal number 300/2021. Next para. Learned judge in the first appellate court, after securing the records and hearing the parties in detail in the light of the grounds set in the appeal memorandum, dismissed the appeal by judgment dated 4th July 2023. Thereafter, the accused is before this court in this revision. Next para. Shri Babu, learned counsel for the revision petitioner, reiterating the grounds set in the revision petition, contended that on the same day of the lease, there was a loan agreement also entered into between the parties, which original of which is with the complainant, and the same has been suppressed by the complainant, and the summon the said document, an application came to be filed by the accused before the first appellate court, which has not been properly considered by the learned judge in the first appellate court, and therefore there is a miscarriage of justice, and sought for allowing the revision petition. First, per contra, learned counsel for the respondent supports the impugned judgments. Having heard the parties, this court perused the matter law on record meticulously. Next para. On such perusal of the matter law on record, issuance of the check and the signature found therein is not in dispute. Defense of the accused is that the check has been extracted taking advantage of the innocence of the accused by the complainant, and not only the present check, there are 2 more checks are with the complainant which has been misused by the complainant. First, if an the check, if the check is misused, comma, as is found from the reply notice, comma, what is the positive action by the, taken by the accused, that too, when he had the benefit of the advice from a lawyer, is a question that remains unanswered on behalf of the complaint. First, oral testimony of DW1 did not improve the case of the accused in this regard in any manner. First, next para, no efforts were made by the accused before the trial court for the summoning of the loan agreement, or any evidence, any witness has been examined on behalf of the accused. At least the photocopy of the loan agreement should have been marked in the evidence of the DW1. First, no such effort has been made. Under such circumstances, comma, trial magistrate and the learned judge in the first appellate court, believing the case of the complaint and raising the presumption under section 139 of the Negotiable Instrument Act and convicting the accused for the offence punishable under section 138 of the Negotiable Instrument Act, is just and proper and requires no interference in this by this court, that too in the regional jurisdiction. First, next para, having said this, comma, it is seen that the learned trial magistrate has imposed sum of rupees 5,60,000 as the fine amount, and of which sum of rupees 5,50,000 is ordered to be paid as compensation, and 10,000 towards the defraying expense of the state, which has been confirmed by the learned judge in the first appellate court, needs interference in as much as the list is privy to the parties and no state machinery is involved. Accordingly, following order, revision petition allowed in part while maintaining the conviction, so and so, ಅದೆಲ್ಲ ಹಾಕು. ಇದರಲ್ಲಿ 1 ವರ್ಷ ಇದು simple imprisonment. Time is granted till 10/7. ಏನಮ್ಮ? Very good.
Your Lordship, serial number 55.
ಏನ್ ಶಂಕರಪ್ಪ?
ನಾಳೆಗೆ ಹಾಕಿದ್ರೆ
ಯಾಕೆ, ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
ಚೆಕ್ ಚೆಕ್ ಅಲ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇದೆ. Produce CBI check, CBI State Bank of India check. In spite of that, 138 case has been issued and
ಏನಿದೆ ನೋಡೋಣ. ಮಧ್ಯಾಹ್ನ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಬಂದಿದೆ.
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಇದೆ, 3 ಜನ ವಿಟ್ನೆಸ್ ಬಂದಿದ್ದಾರೆ.
ಆಲ್ ರೈಟ್, ಅಟ್ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಶಂಕರಪ್ಪ, ರಿಲೀಸ್ tomorrow.
ವಾರೆಂಟ್ ಇಶ್ಯೂ.
My lords, this to serial number 16, my lords. They arguing counsel.
ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಮ್ಮ.
My lords, the arguing counsel is not well, my lords.
Let us see in the afternoon.
Yes.
What is the urgency to move a matter in 140?
Yes,
My
Court is sitting since 10:30.
Blood serial number 57, Mala. Blood check amount is 8 lakhs, Mala. I already deposited 2 lakhs, Mala. Out of,
ಮಧ್ಯಾಹ್ನ ತಗೋತೀನಿ ವಕೀಲ್ರೆ, ಅವಾಗ ಹೇಳಿ ಏನ್ ಬೇಕು.
Blood, out of 6 lakhs, I am ready to deposit 50% of them.
ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ಮಾಡೋಣ. Why at 1:30?
I have got, my son has been admitted to hospital.
Come tomorrow. We'll consider it.
Kindly post.
Accused in JC ನೆನ್ನೆ ಹೇಳಿದ್ರು 50% ಅಮೌಂಟ್ ಡಿಡಿ ರೆಡಿ ಆಗ್ತದೆ ನಾವು ನೋಡಿ ನೆಕ್ಸ್ಟ್ 50% ಅಮೌಂಟ್ ರೆಡಿ ಆದ್ಮೇಲೆ ಮೆಮೊ ಮಾಡಿ ತಗೊಳ್ತೀನಿ ನೆಕ್ಸ್ಟ್.
ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ, ಅದ್ರಲ್ಲೆಲ್ಲ ನಿಧಾನಕ್ಕೆ ಮಾಡಿ. ಸೋಮವಾರ
ಜೇಸಿ ಇದ್ದಾರೆ,
ಸೋಮವಾರ
ಜೇಸಿ ಇದ್ದಾರೆ.
ಇರ್ಲಿ, ಇವ್ರೆ ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಜೈಲಲ್ಲಿ ಇದ್ದಾರೆ. ಯು ಹ್ಯಾವ್ ವೈಲೇಟೆಡ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಹೈಕೋರ್ಟ್, ದೇರ್ ಫೋರ್ he is in JC.
ಸಸ್ಪೆಂಡ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಆಗಿರಲಿಲ್ಲ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು, ಅವಾಗ ಕಂಪ್ಲೇಂಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು, ಅವಾಗ ಅರೆಸ್ಟ್ ಆಗಿದ್ರು. ನಿನ್ನೆ ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ.
ಯಾವತ್ತು ಆರ್ಡರ್?
ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ ಬಂದಿತ್ತು.
ಅಲ್ಲ ಇವ್ರೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಯಾವತ್ತು? ಮತ್ತೆ
26 ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಡಿಡಿ ರೆಡಿ.
ಅಲ್ಲ ಇವ್ರೆ, ನಾನೊಂದ್ ಪ್ರಶ್ನೆ ನಿಮ್ಗೊಂದು ಅರ್ಥ ಆಗ್ತಿಲ್ಲ. ಅವ್ರಿಗೆ ಗೊತ್ತಾಯ್ತು ತಾನೆ ಅವತ್ತಿಂದ ಆಗಿದೆ ಅಂತ. ನಿಮ್ಗೆ ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ ಹಣ ಕೊಟ್ಟು ಫೈಲ್ ಮಾಡಿಸಿದ್ರು, ಇಲ್ಲ ಪುಕ್ಕಟ್ಟೆ ಮಾಡಿಸಿದಾರೋ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೀವ್ ಇಡೋದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ನ?
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ.
ನೋ ಸಾರಿ ಸರ್, ಅನ್ಲೆಸ್ ದಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇಸ್ ದೇರ್, ವೈ ಡಿಡ್ ಯು ಫೈಲ್ ರಿವಿಷನ್? ಸಾರಿ, ಮಂಡೇ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್ ಆನ್ ಮಂಡೇ. ಏನೋ ಜೈಸಲ್ ಇದ್ದೀರಿ ಅಂತ ಹೇಳ್ತಾರೆ, ನಿಮ್ ತಪ್ಪು ಅಂತ ಇರ್ತೀರಿ. ಮಂಡೇ
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ, ಸಾಟರ್ಡೆ ಸಿಟ್ಟಿಂಗ್ ಡೇ.
ಈಗಾಗಲೇ 113 ಮ್ಯಾಟ್ರ್ ಇದೆ ಸ್ಯಾಟರ್ಡೇಗೆ. ಇಟ್ಸ್ ಎ ಕಾಂಪೆನ್ಸೇಟರಿ ಡೇ. ಐ ಹ್ಯಾವ್ 113 ಮ್ಯಾಟರ್ಸ್ ಆನ್ ಟುಡೇ, ಪೋಸ್ಟೆಡ್ ಟು ಟ್ಯೂಸ್ಡೇ, ಸ್ಯಾಟರ್ಡೆ. ಕಲ್ಲಿಗೆ ನೋಡಿರ್ತೀವಿ ನಾವು.
12ನೇ ತಾರೀಕಿಂದ ಕಸ್ಟಡಿ ಇದೆ.